Tonight in the Spotlight, Trump's promise to end birthright citizenship. First, what exactly is birthright citizenship? Well, currently in America, it's a legal concept that's supposedly guaranteed by the 14th Amendment, which states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States of the state wherein they reside. Now, on Inauguration Day, President Trump issued an executive order ending birthright citizenship, arguing that babies born to illegal aliens or people on temporary visas are not under the jurisdiction of the United States and therefore not citizens. Earlier this week, a group of House Republicans asked federal courts to decide in favor of Donald Trump by denying emergency requests made by several blue states and immigration advocates to block the order. Now, in a separate case yesterday, a federal judge blocked Trump's executive order, saying it's likely unconstitutional. So, here to break all of this down for us is John Eastman. He's a former Trump lawyer and a senior fellow for the Claremont Institute. So, John, thanks so much for joining us here today. So what's your take on all of this with Trump and his argument against birthright citizenship?
Well, I think his argument in his executive order is clearly correct. What's been most discouraging to me is how ignorant the judges that are hearing these initial rounds of litigation are. I mean, the judge in Seattle, I listened to the preliminary injunction hearing this morning, and the plaintiffs, the states and some individual plaintiffs, just made blatantly false representations about what the state of the law is. This is an open question in constitutional law, whether subject to the jurisdiction covers only citizens and permanent residents domiciled here, or does it also extend to temporary visitors and those who are illegally here? And the government lawyer from the Department of Justice made a spectacular argument, hitting all the points, citing controlling Supreme Court precedent on that very question, citing the records of the debates over the Congress. And when he was done, the judge says, I find this is extraordinary. There's no basis for any of this. He didn't even look at the evidence. And he signed the preliminary injunction order right there without ever confronting or even talking about any of the clear evidence about what the original meaning of that clause was. It was preposterous. And yet I fear we're going to get that in all of these trial courts around the country, and probably in a good number of the courts of appeals before it gets to the Supreme Court, where one hopes the judges there, the justices, will actually take more seriously the original meaning of this clause and look at the arguments instead of just discounting them with the back of your hand.
So, John, I mean, one thing that's remarkable about what's going on now is that, I remember just a few years ago, really, if you made this argument, and you've made this argument very clearly for a long time, people would sort of jump out of their seats and say, oh my gosh, that's terrible. How can you say that? Even on the right. But there's something that's changed where I think a lot of people in the audience, forget the legal audience, they listen and they go, this makes a lot of sense. And you can see, since the executive order came out, you can certainly see outside of the legacy media, people really grabbing on to this argument. So I guess when it comes to the legal path forward, do you think that just by virtue of them denying or making such shoddy arguments as you saw today over and over again, there's going to be public pressure and support for this, putting aside, legally, the legal path?
Yeah, I think so. And, contrary to this judge, and I'm going to name his name, Judge Kuhnauer up in Seattle, he's a senior status judge, was appointed way back by Ronald Reagan, which, one expects the Reagan judges to actually take more seriously very credible and viable arguments instead of giving in the back of the hand. But in the popular presses, there's just this groundswell because the arguments we've been making make sense. Mm-hmm. And, and I listened to a podcast from Megyn Kelly yesterday. And she begins by saying, when she interviewed President Trump back in 2023 about this question, she thought it was just the silliest argument she'd ever heard. And then she read my writings on it and started looking at the underlying support and the actual record. And she's now come to the position that we're probably right. And I think the more people that look at that underlying record, and we've tried to do it in several fashions. We've tried to do it posts on X. We've tried to do it with popular articles, like my article last week or 2 weeks ago when Trump first signed the Order on American Mind, which has now received more than 250,000 views. But we've also done it with very significant and thorough scholarship in law review articles, in briefs before the Supreme Court, on which former Attorney General Ed Meese joined me, in books that Tom West and Ed Erler and others at Claremont have done, or other scholars that don't have any connection with Claremont, like Lino Graglia, the late Lino Graglia from the University of Texas, or Roger Smith and Peter Schuck when they were at Yale, and one of them still is, the other's at the University of Pennsylvania. And probably one of the most scholarly judges in the country on the courts of appeals, Richard Posner, in a concurring opinion, said the same thing, that we're probably right about this. So I think the more people actually look at it and get beyond the knee-jerk, well, subject to jurisdiction simply means subject to the law, and if you're here and you're not a diplomat, you're subject to our laws. That is a sophomoric understanding of the debate. And it's gotten so silly. People say, well, if they're not subject to our jurisdiction, then illegal immigrants can't be detained and deported for any violation of the law because they're not subject to our jurisdiction. I mean, that's just stupid. And yet serious scholars are throwing that argument out there, refusing to accept the distinction between being subject to our territorial jurisdiction. You follow our laws while you're within our borders, and subject to the more complete jurisdiction in the sense that you owe allegiance to this country, something that people that are just temporarily visiting, and certainly people that are here illegally, don't have. And, we don't have to make this up or pretend. I mean, Senator Howard, the author of the language, was asked that very question, and he said unambiguously, it means subject to the complete jurisdiction. That you owe allegiance to this country, not just temporary sojourners was the phrase at the time, passing through and visiting. And so I think the historical record is compelling. And the first couple of Supreme Court cases to look at that issue actually agreed with us. And there's been no Supreme Court case ever saying that the children of illegal immigrants or the children of temporary visitors are citizens. And yet this judge up in Seattle, like the judge in Maryland, and I'm sure like the judges tomorrow and next week out in the Northeast, where these other cases are pending, are gonna completely ignore all that and act like this is a done deal and it's been settled for centuries. It's just nonsense.
All right. So there are so many court cases, right? You're laying them out. On one hand, right, there's the 14th Amendment. And then on the other hand, you have Trump's executive order. So take me through legally how you would go about unwinding this for the average people out there that they could understand.
So the 14th Amendment, and the one thing that the scholars on the left are right about is if the 14th Amendment actually mandates birthright citizenship, the president can't change that by an executive order. And I fully agree with that. And I think everybody does. The question is, does the 14th Amendment mandate birthright citizenship? And most people, and I'll give you one example. Senator from Hawaii, Hirono, posted on her Twitter account last week, the Constitution is clear. All persons born in the United States, ... are citizens. That's what she wrote on her Twitter account. Well, the ... elides over the critical phrase, and subject to the jurisdiction. And here's the short argument. Subject to the jurisdiction meant subject to the complete jurisdiction, not the mere partial or territorial jurisdiction. And if it's subject to the complete jurisdiction, then people who are temporarily visiting and people who are illegally don't have children that are automatic citizens, because the children through their parents don't owe allegiance to this country. They owe allegiance to a foreign power. And the 14th Amendment never was intended to provide automatic citizenship for them. And all that Trump has done is clarify what the original meaning of that phrase was in the 14th Amendment. Now, Congress is free if they want to extend citizenship to people above the Constitution's mandate. They're free to do so under the naturalization power. But riddle me this. If Congress were to have a bill that says anybody from China that lands in L.A. for a month before the baby's born and then goes back home, that baby's a citizen, do you think there's a chance in hell that bill would pass this Congress with the American people watching closely on what they're doing? It would not, just as it wouldn't have in 1868. Oh, and then if you ask the next question, how about the children of people who have come here illegally? You're going to give them citizenship as a reward for that illegal conduct, that breach of our sovereignty, that illegal crossing of our border? Overwhelmingly, the American people would say no. So if this question is ever presented to give additional citizenship beyond what the 14th Amendment requires, it's a resounding no. And the notion that we can somehow interpret that constitutional amendment as doing what the American people never voted for, never would have voted for, is just utter nonsense.
I really appreciate the way in which President Trump has been articulating this lately. He's been making the case publicly, and I of course grew up hearing it from people like you, learning from you. When you look at this now, one of the things that he says, of course, which is also great, which we should note here, is that there's a reason most countries don't do this because it doesn't make any sense throughout the rest of the world. But let's see. It sounds like you think this is going to go to the Supreme Court. And if it does, I mean, you respond to that, but if it does, how do you break this down when it comes to the judges who are historically right-leaning?
Yeah, so let's talk about the process of getting to the Supreme Court first. The granting of a preliminary injunction blocking an executive order of the president is immediately appealable. And so the Department of Justice can bring immediate appeals from these several cases. Once it's at the Court of Appeals, they could even file a petition for writ of certiorari, asking the Supreme Court to take the case up even before the courts of appeals have ruled. Now, I don't know if they're going to do that, but that would be the quickest time frame to get there. Once it gets there, I think it's a crapshoot. I'll guarantee you there are three justices who would never, because they don't think they're bound by the original meaning of the Constitution. They just think that this is a political move, and the three justices on the left would never vote to uphold Trump's executive order. I think the most serious originalists, Thomas and Alito, and arguably Gorsuch, are going to at least take very seriously the arguments that are being made. And I've been reading the Department of Justice briefs. We were prepared to weigh in with an amicus brief on behalf of the Claremont Institute if need be, but they hit every single argument that I would have hit. They cited the sources that I would have cited. I think they were probably had our law review articles in front of them, because a lot of this stuff is archaic, and they had it all in their briefs. So it was very good, very well done. And I think those three staunch originalists are at least likely to take very seriously the argument instead of giving it the back of the hand like this judge up in Seattle did. The question is, what about the justices in the middle, Roberts, Kavanaugh, and Amy Coney Barrett? Certainly Kavanaugh and Amy Coney Barrett purport to be originalists, and one would hope that they would take seriously these arguments. Roberts mouths that he's an originalist, but he's had some doozies of opinions that haven't followed that line. And there's a lot of politics swirling around this case. So it's hard to say particularly how Justice Roberts would come down. But I think there's a fair chance of getting at least 5 votes here. And if they take this seriously, if they actually do the work, roll up their sleeves, look at the original arguments, and they don't have to read all thousands of pages of the debates. I mean, we've pulled it out for them in our own scholarship, and that'll be part of our amicus brief there. And the Department of Justice is tapping those resources as well and identifying what the exact language is, what it was meant by the people that drafted it, by the people that authored the 14th Amendment and that particular language, by the people that ratified it, by the leading constitutional treatise writer of the day, Thomas Cooley, by the first couple of Supreme Court cases that even looked at this question. All of it is in sync with our view on this, by Secretary of State opinions in the 1880s, where a Scottish guy was born here while his dad was visiting, and the Secretary of State said, "You're not a citizen. You don't owe allegiance to the United States." So executive, legislative, and judicial branches and the scholarly treatises, the legislative history, the fundamental principle of consent of the governed, rather than this old feudal notion of if you're born on the king's soil, you owe the king perpetual allegiance. All of those line up to support the president's executive order. And if any justice is willing to look at that and to take seriously those originalist views, I think we win.
Well, I'm glad it's finally getting its time in the sun. It is long overdue. John Eastman, thanks so much for joining us today.
Well, thank you very much, and let's keep shining a light on this and calling out these judges. They're not doing their job. This judge up in Seattle, quite simply, didn't even bother to look at the arguments. When he signed the temporary restraining order last week, he admitted he'd already signed it before they even had the oral argument. This is an outrage on something as significant as this, as carefully thought out by the President of the United States as this, that the judges wouldn't even bother to give it the time of day.
Absolutely. Keep us posted, John.
All right. Thank you.
And Matthew, you can tell John is going to forget more about this than we will ever learn in the rest of our lives about this topic.
Well, I mean, the thing that's maddening is that this argument is out there. He's made this argument. Many others have come together and made this argument from Claremont and other places for a long time. And it's forceful because it's true, because it has the burden of evidence on its side, and it comports with the principles of the American constitutional republic, as he said. And so I think what's going to happen is people like us are going to hold these judges to account every step of the way, because right now the audience knows, the base knows, that President Trump is absolutely correct, and they don't like this asinine idea that you just come here and you're magically an American. That's crazy.